Welcome back. I am your host, Dave, 10-year intellectual property attorney, dealing with everything from copyrights, trade secrets, patents, as well as trademarks. And today, we got a good one for you guys. It seems like the storage companies are kind of at odds with each other. U-Haul, as well as Public Storage, is in a public battle for, based on a trademark that it seems like Public Storage owns. And this is an interesting one that I think you guys are going to learn a lot more because it has a different aspect to it that you typically don't see when it comes to trademark battles. So before we get into it and before I pull up the article, some housekeeping items, please hit the like button for the YouTube algorithm as well as hit the subscribe button to be a part of the IP community. I would love to have you a part of the IP community, and you're definitely going to get some knowledge, some game. I was just at the Shark Tank Reunion Conference down in Tampa this past weekend, and man, just the amount of game that I picked up just on the business side, but being able to kind of impart wisdom on the participants of kind of Shark Tank over the last 16 seasons on the IP. I mean, they enjoyed it. I enjoyed it. It was a win-win. You'll definitely want to be on the lookout for that content that's going to come out over the next couple of weeks. And part of being notified of that is hitting the subscribe button as well as turning on the notifications. Now, with trademark law, typically you will see it with the phrase, for example, Nike, just do it. Sometimes you may see a logo, for example, Nike, the check mark, or maybe a word mark, which is again just a word Nike. In those situations, Nike has trademark protection on all three of those. The phrase "just do it," the Nike logo, as well as the word Nike. And that's typically what you see as it relates to trademark protection. But a lot of people don't know you can get trademark protection on a lot of different things. You can get trademark protection on a sound. You can get trademark protection on the way something is like trade dress is what we call it, the kind of overall look and feel of it. You can get trademark protection on a color. Just think of U-Haul, for example. I mean, not U-Haul, but UPS, for example. They have a trademark on the color brown. If a color brown is non-functional and it's distinctive, particularly to your business, you can get trademark protection on it. And it seems like Public Storage has trademark protection on the color orange, which I think is interesting because, again, I don't know. From back in college at Michigan State, I feel like I have seen U-Haul use the color orange, but maybe Public Storage was kind of using it beforehand. But again, really, that doesn't even matter. And this is why I tell people all the time: make sure you file for trademark protection because, okay, you're using it. That's all good and dandy, fine and dandy. But the first person who files trademark protection is going to be the person that's going to be able to get nationwide rights to it. I think I did a video and it's up to like I'm over a couple thousand views with UGG because the company who was originally had the term UGG, going to the sheepskin shoes, boots over there in Australia. They, even though I think 1945 is when a company that was been around for 5 generations. They had maybe 1974 is when the family company had kind of coined the term UGG, but the U.S. company that's owned by, I think, Decker Corporation, they didn't get a hold of the trademark until like later on in the 70s. So again, to this day, the Decker Corporation, which is a U.S. corporation, has ownership of the term UGG, even though the Australian company was probably the first to use it. So my whole point of sharing that story is, hey, if you're using something first, that's good, and that'll help you out from the geographical region. But if you want nationwide protection with regard to a trademark, whether it's a sound, whether it's a logo, whether it's a phrase, whether it's a color, you need to file trademark protection with the USPTO. It seems like Public Storage, shout out to them, they filed trademark protection for the color orange with the USPTO, even though U-Haul claims that they were using it first. So it's like, okay, yeah, you were using it first, but you didn't file for trademark protection on it. Public Storage did. And it seems like they have nationwide rights to it as a result of that. So let's pull up the article here so we can go through it quickly. And then I would love to hear from you guys in the comment section. Let me see if I can do it a different way. So definitely let me know your comments at the end. Hopefully you guys can see this. Let me see if I can make it a little bigger. I don't really like the way it did. Okay, let's go to it. So this was kind of a week ago. January 23rd. To be eligible for trademark registration, a color must have acquired distinctiveness and must not be functional. I just kind of said that. The whole part of trademark, and that's not just a color, whether it's a logo, whether it's a word, whether it's a phrase, it has to be distinctive and it can't be functional. Particularly in the color cannot be functional. And to the extent that it has acquired distinctiveness, you can get a trademark on a color. Recently, the federal court discussed the importance that a color might not be functional. A new lawsuit filed by U-Haul against Public Storage will turn on whether or not exclusive, non-exclusive use can be distinctive. U-Haul International filed suit against Public Storage, arguing for Public Storage continued use of the color orange and the word orange in connection with its self-moving and storage business. Obviously, Public Storage. Hey, back when I was in college, I used U-Haul. I've never used Public Storage, at least for kind of moving. I guess I didn't know they had a moving company. I knew, obviously, as a name implies, it's a storage company. I didn't know if Public Storage had a moving component to it. Obviously, U-Haul has storage as well as trucks that help you move. But I digress. Let's continue on here. The lawsuit arises from a cease and desist email sent by Public Storage, alleging that the use of the color orange caused consumer confusion and infringe on Public Storage trademark rights to the color orange. So again, which everybody should be doing to the extent that you get, whether it's patents, whether it's trademarks, whether it's copyrights, if you get wind that somebody's infringing your IP, you need to send them at least a cease and desist letter. I was talking at the Shark Tank conference just to a few people, like, if you're not going to at least send a cease and desist letter, you're going to let people willy-nilly infringe on your IP, you might as well don't even get IP, which I think you should definitely get for your business, for your product, whatever the case may be. But to the extent that you get it, you have to be at least willing to send a cease and desist letter. It seems like in this case, Public Storage, because they own the trademark to the color orange, and as well as it seems like a couple of word marks and phrases or whatever the case may be, they sent a cease and desist letter to U-Haul saying, hey, you're infringing on our trademark. Now, again, if they don't stop the infringement, then a lawsuit may commence or whatever the case may be, but you have to, at the very least, be willing to send a cease and desist letter. So let's move on here. In this complaint, so it seems like based on the cease and desist letter, seems like U-Haul just filed a lawsuit, which is interesting because typically the person who sends the cease and desist letter will file a lawsuit, but U-Haul, which is the receiver of the cease and desist letter, they went ahead and filed the lawsuit, and it seems like they're trying to maybe petition to get this trademark or these number of trademarks from Public Storage canceled with the USPTO. So in this complaint, U-Haul alleged that the Public Storage is attempting to improperly monopolize the color orange and the term orange by fraudulently maintaining trademark registrations with the USPTO. Again, newsflash, U-Haul, that's the whole point of filing for any type of IP protection. Again, with the patents, the government say, hey, we're going to give you a 20-year monopoly of for the product or for your invention. That's the whole point of a patent with the trademark, and that's a similar thing. You're going to get a monopoly on your invention, on your creation, and that's the whole part of trademark. So that's interesting that the U-Haul put that in his complaint. According to maybe they thought that, again, they're not using the color orange, which is weird because, as we see here in the building down here, Public Storage are using the color orange. Clearly U-Haul is using it as well, but let's continue on here. According to U-Haul, Public Storage falsely represented it had exclusive rights to these marks in its trademark applications, thereby excluding competitors such as U-Haul and hundreds of independent moving and storage businesses from using the color orange or related terms. Now, that is interesting. When did, I guess, the color orange kind of come from? Like I said, I got first wind of it through U-Haul, but why did they start using orange? Why not yellow or green or some other color for moving and storage? Why was the color orange? Somebody had to kind of come up with that. And to the extent that one of the audience members knows the answer to that question, please leave it in the comment section. But apparently it seems like U-Haul is saying, hey, Public Storage falsely represented it had exclusive rights to the marks and the trademark applications, but others were using it, including ourselves. Let's continue on here. U-Haul alleges that it has been using the color orange in association with its moving and storage services since 1945. So it seems like U-Haul has been using this. I didn't realize that U-Haul has been around since 1945. But it seems like U-Haul is saying we've been using this stuff since 1945, predating the Public Storage recent claims. U-Haul contends that Public Storage assertion that the color orange has acquired distinctiveness for services baseless. In April 2024, U-Haul filed letters of protest with the USPTO seeking the cancellation of Public Storage trademark registration for orange storage. Orange is the new size. Orange door storage insurance. So it seems like in addition to the color orange, which seems like Public Storage has protected, they have a number of different slogans, which again is still weird for me as an IP attorney because it's really the first one. I mean, again, if you're using it first, then okay, you get some protections within that geographical region. But if somebody else is using it and files for trademark protection with the USPTO, then they get nationwide access, even though you're using your mark. So it seems like U-Haul is trying to say, hey, yeah, Public Storage filed for trademark protection, but they weren't. It was other people were using it, and it's like, okay, that happens all the time. Yeah, I'm using multiple people are using a mark, and that's why I always tell people you need to file for trademark protection, because to the extent that you file for trademark protection first, then you get nationwide rights to it. Yeah, if you're using this thing in Maine in a small town, yeah, I guess the person who filed for trademark protection and gets it granted, they can't force you to close down shop. But again, they can force you to not being able to expand because they have nationwide rights. So it's weird that U-Haul is trying to say, hey, they filed for it first, but they weren't using it first. That's the whole point of filing for trademark application, so that you can kind of stick your, put your fork in the road and kind of get nationwide protection on it. It seems like U-Haul in this case, while I read this paragraph, they're kind of butthurt from not being first to file for trademark protection. That's kind of what that reads to me, but others may disagree with me. U-Haul also alleges Public Storage, in its efforts to monopolize the use of the color orange, has moved away from predominantly using the color purple in combination with the color yellow and orange to solely use the color. And that's what you should do. If you got trademark protection of the color orange, why not kind of continue to kind of strengthen that trademark protection by branding and using the whole color orange? That's the whole point of trademark protection, is they want to, you're identifying, the consumers are identifying your trademark, in this case, the color orange, with your brand. And if you have trademark protection on the color orange, why not continue to use orange as the predominant color in your advertising? Again, this is kind of some weird statements in a lawsuit, at least in my opinion. Through his lawsuit, U-Haul is asking the District Court of Arizona to declare that its use of the color orange and the term orange do not violate Public Storage alleged trademark rights. U-Haul also seeks the cancellation. So again, they're definitely trying to get Public Storage mark to be canceled with the USPTO. Seems like they're also trying to say, hey, man, U-Haul, y'all are cool, which is weird, especially in light of this last paragraph. In response to U-Haul's complaint, Public Storage filed a motion to dismiss for failure to state a claim and questioning the suit as a publicity stunt and an anti-competitive maneuver. Public Storage further asserts U-Haul created a website which shows no affiliation with U-Haul in order to produce evidence for the USPTO. Through its response, Public Storage reaffirms its intention not to intervene with U-Haul's use of the color orange in relation to its movement. I think that's BS, that last sentence. Pretty much it seems like Public Storage is reaffirming its intention to not intervene with U-Haul's use. So the way I read that is, hey, we're not going to mess with U-Haul because they're using the color orange in relation to moving and storage services. Yet y'all sent them a cease and desist letter, which it shows at the beginning of the actual article. The lawsuit arises from a cease and desist email sent by Public Storage. So that's weird to say, we're going to send you a cease and desist letter, but we're not going to intervene and stop you from using the color orange with regard to your storage and moving services. It seems like Public Storage is kind of playing some games. Seems like U-Haul is a little bit butthurt about not being able to kind of get trademark protection first on the color orange, even though they may have been using it first. And again, this is all part of the IP and trademarks. Who is the first to file? It seemed like Public Storage was the first to file. Again, U-Haul maybe a little bit butthurt about it. It'll be interesting to see how this plays out. I may have to kind of go through this complaint in its totality when I do the live on Sunday, because this is an interesting one, I think. But in the meantime, let me know what you guys think in the comment section. Who do you think is going to win? Who do you think fault it is? Do you think U-Haul is butthurt? Do you think Public Storage is trying to say, hey, man, we won't sue you, even though they're sending cease and desist emails to say stop using the mark? Seems like there's a lot going on in this one. But hopefully you guys got something out of it. And at the very least, hopefully the point that you guys got was make sure you file for trademark protection at the beginning. You don't want to do this stuff later on. File for protection at the beginning. And really, that's all IP, not just trademarks, but copyrights, patents. You want to file for this stuff at the beginning so that you can kind of put your stake in the ground and be able to kind of prevent others from being able to get trademark on that. So let me know what you guys think in the comment section. Please hit the subscribe button, and see you guys next time. Peace.